We will go on the record in the matter 25 CM 116, State of Wisconsin versus Jeffrey Holland. The state appears through Assistant District Attorney Jose Vila in person. Mr. Holland appears in person with counsel Joel Feliski. We're set here today in this matter for a plea and sentencing. Mr. Feliski, is this matter proceeding as such?
It is, Your Honor. I'm very pleased to report that Mr. Holland, as of yesterday, completed the domestic violence program with Dave Hatch. I have here in that as document number 17 in the electronic file. Based on that, we are ready to proceed with the offer from the state, which would be a plea to count 1 in 25 CM 116 as amended to disorderly conduct without the enhancer, and a joint recommendation for court costs. I have a completed plea questionnaire with me, which I realize now I have not signed. I am adding my signature at this very moment. May I approach?
You may. Thank you. Formal motion to amend to disorderly conduct.
So made.
Granted. Mr. Holland, I have in front of me a plea questionnaire waiver of rights form. Do you recognize the document?
Yes, ma'am.
Is that your signature on the second page?
Yes, Your Honor.
You are pleading guilty to an amended count of disorderly conduct. Did your attorney thoroughly go over this document with you thoroughly?
Yes.
Essentially word for word?
Yes.
And you understood everything completely?
I did.
Did he thoroughly go over your constitutional rights with you?
Yes.
Do you understand them completely?
I do.
Do you need me to go over those rights with you in any more detail?
No, Your Honor.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
I do.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
I do.
Do you understand here, the state would have to prove on or around March 14, 2025, that you engaged in either boisterous, unreasonably loud, or otherwise disorderly conduct that tended to provoke a disturbance?
I did.
Do you understand the maximum possible penalty could be a fine of up to $10,000, or excuse me, sorry, I looked at the A, $1,000 and a maximum possible penalty of 90 days of incarceration or both?
Yes, Your Honor.
Do you understand that there is an agreement here for costs only, but do you understand I'm not bound to follow that?
I do.
Said differently, I could sentence you to the maximum possible penalty if I thought it was warranted?
I do.
Did your attorney go over the criminal complaint with you and the facts that are alleged in that complaint?
He did, Your Honor.
For the most part, are those facts accurate?
Yes, Your Honor.
Are you pleading guilty to disorderly conduct because you are guilty of that conduct?
I'm guilty, Your Honor.
Mr. Feliski, may the court use the probable cause section along with the statement made by your client to find a factual basis?
So stipulated.
Has anyone made any threats or promises to you, Mr. Holland, for you to plead guilty today?
No, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing?
Yes, Your Honor.
And voluntarily?
Yes, Your Honor.
Has your attorney represented, well, are you satisfied with his services?
I love him.
Well, that's good. Do you have any questions for the court or for your attorney before I proceed?
No, Your Honor.
Then as to the amended count, disorderly conduct without any modifier, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the amended count. A judgment of conviction will be entered today. Argument, Mr. Vila.
Thank you, Your Honor. I think the joint recommendation here is appropriate. This was a situation that could start as a verbal altercation and escalated to the point where Mr. Holland pushed the victim, in this case, down to the floor, leading us to where we are today. Since that time, he's completed that domestic violence education course with Mr. Dave Hatch and hopefully has gained some kind of valuable insight as to how to relate to difficult situations and emotions and how to pull himself out of positions where he feels situations may be unraveling. With that, I think cost is more than appropriate. I would ask the court to adopt. Thank you.
All right. Thank you. Mr. Feliski.
Thank you, Your Honor. I agree with the state here. I do think that this is an appropriate resolution to this matter. The main concern here, I think, being to provide some resources, provide some education for Mr. Holland to avoid having this situation replicate itself in the future. he's followed up on that. And I think this experience overall has been a very valuable lesson for him. I think he understands here how serious things can get, how they can escalate to this point. I think certainly that he does not want to be in this position again before the court or any other court for that matter. Considering that he's completed that class as of today, I do think that costs are going to be an appropriate deterrent. I think they'll be effective for the purpose of, again, avoiding the situation recurring. So I do think this is an appropriate agreement, and I would ask the court to follow it. Thank you.
All right, Mr. Holland, is there anything you want to add or you want to state here today?
No, Your Honor.
Okay. All right. Well, you've done the work. You've went and completed the class, and I think you've learned something from this. Although the initial charge is more serious and the amended charge is less serious, you've done the work and you're showing that you want to make some changes in your life. So I believe that the agreement is appropriate. So I will adopt the agreement. I'm going to assess $443 in fines and fees. I believe you need a payment plan. Is that correct?
That would really help, Your Honor. Like 3 payments would be nice if I could.
Okay, so if you can do it in 3 payments. $150 a month. Is that doable?
It'll have to be.
Well, I'll just say, why don't we just do $100 a month? It'll take you a
Okay.
little bit longer, but then you
Okay.
can have a little bit more time until it's paid off in full, okay?
Sounds good, Your Honor.
All right, so $100 a month. If you fail to pay the fines and fees, not only will a civil judgment be entered against you because you're always going to owe it, but the court will issue a warrant and you could sit up to 6 months in jail. So just make sure you make that minimum monthly payment, okay? You have 20 days to appeal. If you fail to appeal within 20 days, you do lose that right. I'm ordering you to provide your DNA. So you're going to need to go to the jail and make sure they have that, but you will be able to request it be expunged from the system through a written letter to the Department of Justice. It's easy to do. You can Google it or you can ask Mr. Feliski and he can help you. It's not to the court, it's to the Wisconsin Department of Justice. I believe that covers everything. Mr. Vila,
I would agree, Your Honor.
Mr. Feliski.
Nothing further.
All right, then we are adjourned. You can come get your form, go to the Sheriff's Department. First payment will be due in May, okay?
Yes, ma'am. Thank
All
you.
right, thank you. Mr. Chavarria,
She scampered, Your Honor. I will make a special appearance.
we will go on the record in the matters 24 CT 66, 25 CT 27, State of Wisconsin versus Andrew Wellman. The state appears through Assistant District Attorney Jose Vila in person. We have Mr. Wellman appearing in person with counsel. Emma Hunu making a special appearance from Ms. Sherwood. Ms. Sherwood was appointed to this case relatively recently. Mr. Wellman is here in person. We're set for a status conference. This is getting very old. And so quite honestly, the court is going to set it for a trial unless Mr. Wellman tells me he's super close to getting his license. Super close to getting your license.
No, I'm right where I was 2 weeks ago.
I think, Your Honor, given the age of the case, if we set it for trial but set it a little bit out, Attorney Sherwood advised that she just wanted an additional date to speak with the district attorney.
Mr. Vila,
This is the District Attorney Schmidt's case, so if Attorney Sherwood needs to confer with him, no issues on that front.
well, do you have her calendar so I can set it for a trial?
I do, Your Honor.
Should only be a 1 day. We're doing the 24 CT 66 first. Backup is the 25 CT 27. I can do June 22nd or 23rd.
The 22nd would work for Attorney Sherwood.
All right. Does the 23rd not work?
The 23rd would work.
Let's do
For
the
her.
23rd, and just because sometimes with jury trials, they would they don't like to be called in right on a Monday.
Makes sense, Your
So
Honor.
June 23rd, we will set it for a trial, June 23rd. I'm going to set the final pre-trial for June 1st at 1.
That'll work for Attorney Sherwood as well.
And so you can let her know, let Ms. Sherwood know that I believe the offer is get the license and they're both dismissed, or plead to one of the counts of operating for costs.
Okay.
There's always other options. Like I know Ms. Landgraf has argued for a deferred judgment on a matter to be held open for 6 months. Those kinds of things with these cases. So you can pass that information along to Ms. Sherwood.
Of course, Your Honor.
All right, thank you. And then you can explain to Mr. Wellman what that means. All right, thank you. You can come get your notice and then you are free to leave. Mr. Mersha. We will go on the record in the matter 26 CF 35, State of Wisconsin versus Leon Chapman. The state appears through Assistant District Attorney Jose Vila in person. We have Mr. Daniel Chapman, Defense Counsel in person, along with Mr. Chapman. We're set here today in this matter for an arraignment. Mr. Chapman, were you able to go over the criminal information with Mr. Chapman?
Yes, Your Honor. He understands the one charge and the possible penalties. We waive reading.
Not guilty, please.
He pleads not guilty.
Not guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. All right, we need to set a status date. Address still the same, that P.O. box?
PO Box 103, correct?
And telephone still ends in 9839?
Correct.
About June 11th. 9:45.
That would be, actually, no. I'm here at 11:30 for two other matters, but I have a St. Croix case at 9:30.
Oh, that's right.
I'll be by Zoom on the St. Croix case, but
Can you do 11:15?
yes, I can.
June 11th at 11:15. All right, we will see you then. You can come get your notice and you are free.
She'll give you the
to leave.
notice. I'll call you when I've got the discovery. Have a good day.
Thank you.
We will go on the record in the matter 24 CT 101, State of Wisconsin versus Jacob Lubick. The state appears through Assistant District Attorney Jose Vila in person. Mr. Lubick appears in person without counsel. We're set today in this matter for a status conference. Mr. Lubick, you were getting very close. You needed to get the ignition interlock device and all of those things installed. Where are you now in the process? Of
I
getting
have
the license?
currently passed 2 of the 3 tests that I need for my license.
Passed 2 of the 3?
Yep. And now I go in today to the DMV. They'll assign me my permit. Then I have to hold that for a week, and then I can assign. They will set my driving test, my road test.
They said it. You don't just go in and set it yourself.
I don't know, because when I was in there dealing with her, she kind of just pushed the test on me. Like, I was unprepared for the test, but luckily I passed anyways. And then she said after I hold the permit for a week, then I am eligible to schedule my test for the road test.
Okay, your last status. 'Cause you're getting close to. That's all you need to do.
Yep, that's all I need to
You have
do.
the ignition interlock
Yep.
device. You have your SR22.
I don't need one.
Oh, that's right.
Mhm.
Okay, June.
The only thing
1st.
that I would have my permit already, but I had to reinstate my driving privilege in the state of Minnesota. Got that done right away.
Well, I'm
So
glad that you did that.
Yeah.
That can sometimes be
Yeah.
a hassle.
Yeah.
June 1st at 1. Okay, June 1st at
Awesome.
1. So if you get your license before that date and time, bring it over to the state, to the district attorney's office, then you won't need to appear, okay?
All right.
Unless you want to come show me that bright
I
and
kind of
shiny.
do.
It'll probably be a paper at that time, but you can come over here and get your notice. Call the public defender's office.
No, I called, I haven't got any hold of the lawyer yet.
Who is your lawyer?
Um,
Oh, you said Mr. Davis. Mr. Davis is right there. That's Mr.
no, I
Davis.
think it's Mr. Eric.
You told me Mr. Davis.
Eric, I didn't talk to you, show you?
Sure, that looks like Mr. Davis's stuff.
I don't know. I have not met him.
Oh, no, this is Weston Dunn. Oh, I don't. Well, we're gonna have to move
'Cause I
forward and
did-
get
I
this
just gave him
going.
5 grand.
What?
I just gave him 5,000.
Oh, you did, oh, you paid him money? Okay,
I did.
okay, go have a seat.
Here,
Right down there. So you paid him, but,
I did pay him, yes, I just paid him, I don't know if he got his money yet or what's going on.
Okay,
I
so-
tried- He called me earlier, and, I missed the call, so I called him right back, and I never heard.
read his name to me, please.
I don't have my glasses on, but I have no glasses, so I can't see.
Oh, well, then bring it back.
I'm sorry, man.
No, that's okay. Thank you. From Wanakee? Wow. Oh, Mr. Pangburn. Okay, here.
I didn't know if you want to call me, but.
Nope, I haven't heard anything. Okay, so. Okay. Okay, that's fine. Okay, so what,
The first time you emailed me something.
that's fine. We'll just go through with the initial appearance. We'll set it. And then if it doesn't work for him, the next hearing, we can just move it. Okay. We will go on the record in the matter 26 CM05, State of Wisconsin versus David Kisslinger Sr. The state appears through District Attorney Kevin Schmidt in person. Mr. Kisslinger Sr. appears in person without counsel. Off the record, Mr. Kisslinger showed the court that he has a letter from an attorney. He indicates he has paid a retainer, and he did so on Monday. We were here back on January 28th when the court set a whole month ahead to allow Mr. Kisslinger to try and save money to put down a retainer. Mr. Kisslinger, off the record, you indicated we can proceed with the initial appearance and then set it for another date. And if that doesn't work for Mr. Pangburn, the court did indicate to you we can move that to a date that works with him. That's what you wish to do here today?
Yes, ma'am.
Okay. Did you receive a copy of that criminal complaint
I believe so.
with that original charge? And you can read, write, you understand the English language?
Yes, ma'am.
And it alleges on or around Friday, December 26, 2025, in Burnett County, Wisconsin, in a private place, you engaged in abusive, unreasonably loud, or otherwise disorderly conduct, which tended to provoke a disturbance. That's a Class B misdemeanor. Upon conviction, you could face a fine of up to $1,000 or 90 days of incarceration or both. Plus, it has the domestic abuse modifier, which upon conviction, you could face an additional $100 surcharge and a federal prohibition to no longer be able to use or possess a firearm for life. You understand that charge and the maximum penalty?
Yes, ma'am.
Do you need me to read anything else on that complaint aloud to you?
No, but the only thing is, when that was brought up, you can see that me and my wife, she said.
I don't want you, I want to hear whatever you want to tell me.
I have nothing to tell you now.
I just want to warn you that anything you say in here, especially on the record or off the record, can be used against you by the state in your case. So I
Okay.
just want you to be very careful in what you say.
I have nothing to say then.
All right.
Thank you.
And so you're still on Tower Road,
Yes, ma'am.
address or telephone ends in 3625.
Not no more, no. I have a new number.
Okay, what is that number?
And that is gonna be a Dickens to find because I don't even know my own phone.
And that's fine. Here's the thing. When we're done here, just go out to the clerk's office and update it.
All right, thank you
Okay.
very much.
So not guilty plea will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. This is an ADA case. What I'm gonna do is I'm gonna set it about a month in advance, okay? For March 30th. And I'm going to set it for 10:30 on March 30th. Your attorney can appear by video conferencing. Okay, so if you call, you can tell him it was scheduled for March 30th by video conferencing, and that's approved. But if this date doesn't work, then he needs to call my assistant and we'll set it for a date that'll work with him.
I'm sure he will once he gets hold of me and we get talking, you know?
That sounds good. And so you can come up here and get your notice, so you have it, and you can talk to him about that and let him know, okay?
All right, God bless you. Thank
All
you.
right, not guilty is entered. Come get your stuff. Thank you. Mr. Davis? You may come up with your first person.
State of Wisconsin versus Don Lovedahl.
Mr. Lovedahl, come on up.
Yeah, I go out to any of the windows at the courtroom.
We will go on the record in the matter 25 CF 28, State of Wisconsin versus Don Lovedahl. The state appears through District Attorney Kevin Schmidt in person. Mr. Lovedahl appears in person with counsel Nicholas Davis. We're set here today in this matter for a status conference. Mr. Davis, please update the court.
Your Honor, the case is not resolved at this time. I am newer on this case. I know this case has been going for quite some time. I'm now the second lawyer. Would the court have patience for another status set at least 45 to 60 days out?
I can't guarantee how far out. I'll try and get around that time, Mr. Davis.
Or-
I do know you are newer on this case.
Or whatever time you can give me, let's put it this way, I'll be appreciative.
I can do April 20th. Video conferencing is fine. I can do 10 o'clock.
Yes, Your Honor, I'll be available.
All right, April 20th at 10. All right, we will see you then. You can come get your notice and you are free to leave. Mr. Lunsman, sorry, Ms. Lunsman. I'm so sorry. I don't know why I said Mr. We will go on the record in the matter 25 CF 78, State of Wisconsin versus Denise Lunsman. The state appears through District Attorney Kevin Schmidt in person. Ms. Lunsman appears in person with counsel Nicholas Davis. We're set today in this matter for a status conference. Mr. Davis, please update the court.
Your Honor, the case is not resolved, but I think it's getting very close. I have been in contact with the District Attorney's office, District Attorney Schmidt. My client is on probation in Polk County. Your Honor, she's going through a treatment program and therapy. She's got other medical issues which she's dealing with at the Mayo Clinic. I wanted to obtain some actual information so I could provide that to the district attorney and in attempts to ask him for something or for some consideration. Is there any way that I could have that same date on April 20th?
April 20th at 10. We'll set that for a status conference. Just make sure, Ms. Lunsman, you stay in close contact with Mr. Davis so that he can pass on the information, okay?
She has been, and she's been a very good client.
Excellent. You can come get your notice and you're free to leave.
Thanks, Denise.
Mr. Oyat.
Judge, may I have 2 minutes with
You may.
Jacob?
Yes, you may. On the record in the matter 25 CM 130 and 131, State of Wisconsin versus Jacob Oyat. The state appears through District Attorney Kevin Schmidt in person. Mr. Oyat appears in person with his counsel, Nicholas Davis. We're set here today in this matter for a plea and sentencing. We also have 26 GF 28, but I believe Mr. Schmidt informed the court that that isn't going to be a non-prosecution case and to be dismissed and read in this matter.
Yes, as an uncharged read-in.
All right, thank you. And so the parties have reached an agreement. Mr. Davis, can you please recite the agreement for the record?
You can go ahead if you want, Kevin.
What?
You can recite it if you want, Kevin. It's a misdemeanor battery, Your Honor, with the domestic. It's my understanding it's a year probation, court cost fine, DNA surcharging, whatever program is required, he has to do it.
And he needs his driver's license still?
He does.
Okay, all right. And it doesn't matter which one he's pleading to, aren't they both similar?
They're both similar, whichever one you wrote on. there is
Whichever
fine.
one I have on the sheet.
Both.
And that's where this courtroom chapter comes to a close. What started as a routine hearing turned into a reminder that the justice system isn't just about punishment. It's also about accountability, plea negotiations, and second chances. But here's the question. Do you think the court reached the right outcome, or should the sentence have been tougher? Let us know your thoughts in the comments, and don't forget to like, subscribe, and join us for more real courtroom breakdowns.
Cases on the sheet.
130.
130.
Let's do 130.
Okay.
All right. So, Mr. Oyat, you've went over a plea question or waiver of rights form with your attorney. Is that correct?
Yes.
And did he go over it thoroughly with you, essentially word for word?
Yes.
And you looked over that document and you signed it?
Yes.
And do you understand everything?
Yes.
You are 26 years old. You have 12 years of schooling. You can read, write. You understand the English language, all correct?
Yes.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney go over with you the maximum possible penalties you face?
Yes.
No drugs, no alcohol, no mental illnesses or disorders?
Just mental health, but
And do you take medication?
yes.
And do you take it as prescribed?
Yes.
Does it interfere with your ability to comprehend or understand?
No.
So you're in a position right now where you fully understand everything.
Yes.
Now, did your attorney thoroughly go over your constitutional rights?
Yes.
Do you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that you're pleading guilty in 25 CM 130 to count 1 misdemeanor battery with a domestic abuse modifier?
Yes.
Do you understand that the state would have to prove on or around July 21st, 2025, you caused bodily harm to AMD by an act done with intent to cause bodily harm to that person without that person's consent, a class A misdemeanor? Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 9 months or both?
Yes.
Do you also understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand the agreement that's been recited on the record?
Yes.
And that it would be for a recommendation of 1 year of probation?
Yes.
Do you understand I'm not bound to follow that, meaning I can sentence you to any sentence that I believe would be an appropriate sentence?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yeah.
Did you go over the criminal complaint with your attorney?
Yes.
In particular, the section called the probable cause section, where it basically says what happened and why you were charged with the crimes?
Yes.
For the most part, are those facts accurate?
Yes.
Are you admitting here today that you in fact did cause a misdemeanor battery without having AMD's consent?
Yes.
Are you guilty of this crime?
Yes.
Mr. Davis, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or promises to you, Mr. Oyat, for you to plead guilty to the charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Are you satisfied with his services?
Yes.
Any questions for the court or for your attorney before I proceed?
I have a court date next month. Is that still ongoing?
With
No.
these actions?
No.
This should not, because with the new case that you were charged with, that's going to be dismissed as part of the deal, okay?
Okay.
All right, any other questions?
No.
Okay. Then as to count 1 in 25 CM 130, misdemeanor battery with a domestic abuse enhancer. But first, you understand with the domestic abuse modifier that upon conviction, you face a $100 additional surcharge,
Yes.
and you could face the federal prohibition to no longer being able to use or possess a firearm for life.
Yes.
Okay. As to the misdemeanor battery with the domestic abuse modifier, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly intelligently and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1 in 25 CM 1.